Hello and welcome to this edition of Let's Talk Human Rights, the video and podcast series from the Maastricht Centre for Human Rights. We talk to researchers at Maastricht University at the Maastricht Centre for Human Rights about what they do, why they do it, and about various diverse human rights issues that have the potential to affect all of us. My name is Sally Thin and I am your host. All, as they say, is fair in love and in war, but is that really true? We've talked a lot about human rights more generally and human rights in peacetime, but today we're going to be talking about what happens in wartime and the restrictions or the protections that we have under international law during war. And to discuss that with me today, we have Wim Muller and Andres Caceres. Wim, would you like to start by introducing yourself?
Okay, thank you. Yeah, well, I'm an assistant professor of international law at Maastricht University, and I came here after spending some time at a couple of other universities, most recently because I wrote my PhD about China and international law, but I also have a long-established interest in the law of armed conflict or international humanitarian law, as well as human rights. So those are also areas in which I conduct research and in which I have an interest.
And Andres?
I am a second-year PhD candidate at the University of Maastricht at the Department of International Law and European Law. And I come from actually quite a long career of being a combatant myself. So having been part of several conflicts in the world. And this kind of interests me in terms of trying to mix the human rights piece with humanitarian law with my experience into the field. And I've had the absolute great pleasure of teaching at Maastricht as well.
Great to have you both. I want to, because I think there are a lot of rules in international law that restrict what can and can't be done, or that regulate what can and can't be done within wartime. So I'm going to start by asking Wim to give us a very brief overview of how international humanitarian law or the law of conflict works. What are the main sort of areas or the main rules?
Okay, yeah. We're actually talking about a very, very specialized field of international law here. So it's one of the oldest fields and also one that kind of tickles people's imagination. But basically, its starting point is all this little booklet, which was written by a Swiss national by the name of Henri Dunant in the 19th century after the Battle of Solferino in the Wars of Italian Independence. He witnessed so much suffering in the aftermath of the battle, where nobody was taking care of the wounded and on the battlefield, and people were just left to rot and to die, that he wrote this piece and basically called for a more humane treatment of people who were affected by armed conflict. First, people who were directly fighting, so combatants, soldiers, but later also civilians who would maybe get caught in it. Now, in the present day, basically the treaties and the international law that regulates armed conflict are found in the Geneva Conventions of 1949 and then two additional protocols of 1977. And then there's a whole body of what we call customary international law, which are basically also rules which have been respected since international humanitarian law developed. Now, the present body of law kind of reflects, on the one hand, this historical origin, because it's originally a European field that regulated wars that were being fought between European states. But at the same time, it also has some more universal kind of underlying principles, because one of the main principles in humanitarian law is the protection of principles of humanity and considerations of humanity. And basically, the entire body of law can be summarized in maybe one sentence or one question, which is: who can states kill? Under what circumstances? How can they kill these people? And also, who needs to be protected while they are doing this? So some people also say, well, maybe humanitarian law is not that humanitarian because it also tells you who states can kill. But this balance between, on the one hand, military necessity and humanity is present throughout that body of law. Mm-hmm. And maybe just one principle that I should highlight, which is kind of essential and which will come back also in our conversation probably, is the principle of distinction. That's a very elementary one, where it says that, in armed conflict, states and armed forces of states need to distinguish at all times between civilians and combatants, and only combatants can be killed, only combatants can take part in the fighting, and civilians are supposed to stay out of it, but they also enjoy special protection because they're not supposed to be killed.
Okay.
Yeah.
And so, Andres, your PhD research is rooted in international humanitarian law and in these rules. Can you
Absolutely.
tell us a bit about what you're looking at and
So
how you're studying it?
yes, well, my PhD research actually has to do with the principle of distinction, and it comes with my experience of in combat of being unable to distinguish combatants from civilians, and it's something that it's noticeable since actually the drafting of the protocols, 1977, additional protocols 1 and 2, which is this nice, lovely book, and which was written in 1977 as a result of not being able to distinguish combatants and establish rules of IHL which quite didn't apply for insurgency warfare. So after 1977, the world community established that combatants had to wear some kind of uniform, had to wear some kind of insignia, and if it's the case that for some reason they're not able to because of the nature of war, they would have to at least carry their arms openly. Mm-hmm. But since 1977 came the Afghan-Russian Soviet War and all the other wars that we've seen in the past, in the recent past, in the past 40 years, and combatants still are unable to meet that distinction. So my PhD has to do a lot with, should combatants meet that distinction? Are the way rules written in a way that it applies to these types of combatants, these types of wars, these types of groups? So yes, it has to do mainly with the application of international humanitarian law as we have written it into the current wars of insurgency, which boils down to what is an insurgency, and what I mean by insurgency are typical guerrilla fighting, freedom fighters, and so on.
And so, is this a new problem? Is this kind of a question of applying older law to new kinds of conflicts, or is insurgency style conflicts have they always existed?
And correct, and that's one of the conundrums is you hear a lot of it's a new type of war, it's a new type of conflict ever since 1970s, 1960s. Well, it has not. You can track insurgency warfare for thousands of years. The Spanish Revolution, the Spanish War of Independence. I'm sorry, the Spanish War of Independence was greatly won by the Spanish guerrillas. That's where the name comes from. 1800s, which were completely disorganized, operated independently, and they eroded the Napoleon army to the point that they eventually had to leave Spain. The U.S. War of Independence itself was a result of guerrilla warfare, and part of the forces that fought on the side of Bolivar and San Martin throughout South America and Latin America in general were also certain forms of guerrillas, insurgencies. And yes, so it's been we had a very long history of insurgency warfare. It's just that there was a period of World War I, World War II. We have big, mighty armies, the French against this and that, the Germans against so and so on, big, large countries. And we kind of lost that. And since then, 1950s, 60s, 70s emerged all this insurgency warfare, and now we kind of see it as a novel type of warfare, where it's really, really not.
Mm-hmm. And is there like a reason that some parties to conflicts fight in this way? Is it to do with the nature of the conflict itself, or to do with the nature of those particular combatants?
According to what I'm finding in my research is that there's a lot of nations that fight this way because that's the way they fight. Mm-hmm. In fact, there's some nations that I've studied that they have an army, a proper army, but the job of that army is to understand they will not be able to hold an large invading force. The purpose of that army is to hold that invading force with enough time, so then the partisans' guerrilla warfare begins in the country, which is a long-term defensive effort. Mm-hmm. And the other groups are that's what they have. They're not professional soldiers, they're not professional fighters, so they work in the day and they fight in the night. That type of mentality, which was very similar to what the Viet Cong had in Vietnam. They were farmers in the day, and at night they did their operations. So it all has to do a lot with the way the society is structured, the way the nation understands their enemies. And insurgency warfare is a fantastic way to equalize the battlefield. When you have a large conventional army and you have a very, very small army, you bring them to a point that they cannot see you, they cannot identify you, and you hit and you run. One of the greatest scholars that talks about guerrilla warfare, insurgency warfare, talks about killing the enemy by 1,000 bites. Very, very small bites, to the point that they can no longer take the pressure, whether it's politically, tactically, or strategically.
So it is also a way of kind of saying that there's some kind of asymmetry between the different parties.
Yes, there's usually the force that engages in guerrilla warfare or insurgency warfare is heavily disadvantaged in terms of usually numbers, usually have a smaller economy, and also they have a lot less technology.
I want to ask a bit more generally then about the principle of distinction, about the way that this works in international humanitarian law. So Wim, you were kind of giving this overview before, including the principle of distinction. What is the purpose of this distinction, and does it still make sense, do you think, to have a distinction between civilians and combatants?
Well, to start with the last bit, yeah, I think it definitely makes sense because, well, the point of the distinction is that you make sure that the people who are not part of the fighting don't get caught up in it, and that they are not victims, that they don't get wounded, that they don't, or that they don't get killed. But yeah, as Andres has just explained, it can be quite difficult. It becomes very difficult if you have parties which are so unequal that maybe one of them believes, okay, we can only fight by bending the rules or by not doing it in accordance with the rules of international law, basically, because our aims are more important than just applying the rules. Now, you also asked, how it works, right? Or because the original, I think Andres outlined the basics of the rule, which is that originally, if you look at the Geneva Convention of 1949, what they had in mind was, well, you have basically two militaries and they're both wearing their own uniforms. It's clearly visible that people belong to the armed forces and they wear distinctive signs. They're carrying their weapons openly. And what you see is that with these additional protocols of 1977, states already agreed, okay, we can tone that down a little bit and accommodate some forms of guerrilla warfare and insurgency warfare by recognizing that you can still be fighting properly and legitimately if you just carry your weapons openly the moment that you join combat, and if you don't need to wear a uniform at all times, but the moment that you start fighting, you're still supposed to actually make clear to your enemy that you are part of the fighters. And the reason for that is indeed to protect those who are not fighting, so that civilians don't get killed by accident. And I think that is one of the basic things. Also, that even the weaker parties in those conflicts kind of agree on, unless they're extremely ideological and think, well, if we make innocent victims, it's worth it for a higher cause. Most of them don't completely think that way, also because it's not very realistic. You lose the support of the general population if you allow that kind of thing to happen. So to give one answer to your question, you see that the rules have already been modified in 1977, and it's worthwhile to examine if they can be modified more, just so that the rules of war that exist don't deal with the kind of conflict that used to exist but is not really fought like that anymore, and instead actually still serve the purpose for which they were designed.
What happens if a civilian does pick up a weapon? So do they immediately lose their protection or their protected status as a civilian? Or is there some kind of leeway there between civilians and combatants?
Well, okay. In an ideal situation, civilians don't take part, right? They don't fight. But of course, many times civilians do fight because either because they feel it's their patriotic duty, or they see that there's a combat fighting taking place, and they're like, I'm not going to stay out of this. There is a set of rules already that it has to do with what they call direct participation in hostilities by civilians, where the moment that a civilian picks up a weapon and starts fighting, they lose their protection against being made the object of an attack. So what it means is they can be shot. But the thing is that the moment that they lay down their weapons again, they become civilians again. They're fully seen as civilians. So then they cannot be targeted anymore. So in that situation, what you have is that somebody who's maybe a member of a less organized group that's not really an army, but is fighting, can say like, okay, yeah, sure, I'm picking up a weapon, I'm going to fight. I know that I run the risk of being killed in that moment, but if I survive and I lay down my weapon, I can also actually make use of the protection that I get from international humanitarian law, because the enemy is not allowed to shoot me anymore, even if they know that I was fighting before. And one of the things that has happened in recent years is that states, but also in scholarship, people have been trying to find ways to kind of avoid this phenomenon, which is known as the revolving door. To call it like that because people can just become, a temporary combatant in a way, but then become a civilian again. This has been done in different ways by different countries, and also courts in different countries. They have come up with different types of solutions.
And do we see, technological developments or anything having an impact on this? I'm thinking particularly of the sort of decentralized training methods that particular armed groups use nowadays.
I think Andres knows more about that.
And one of the issues is technology. So you have some of these. The way that particular clause was written regarding the picking up a weapon and showing up a weapon as the last way, a form to show that you're a combatant, was written for 1977, and it was written as long as they carry and show that weapon on the way to the attack or on the deployment to the attack, not necessarily with the purpose of I show and I shoot within a couple of seconds. Mm-hmm. So in order to give the defender the opportunity to identify that person, here's a combatant and that's a civilian, I shoot the combatant. But what happens when the majority instead of that being the exception, that becomes the norm? Okay, when these insurgencies that don't identify themselves or can't identify themselves or won't identify themselves are more of the norm. Now, also, we're looking at the way the legal background for this in some of these countries is we're looking at Southeast Asian type of colonial or post-colonial warfare, where a lot of these countries had very stringent weapons laws. So not everybody could carry an AK-47 around town. Not everybody could. So being able to identify a person with an AK-47 that was not part of the occupation forces was easily identifiable. That's chances are they're a combatant because they're carrying a weapon. But what happens in countries like, for example, Iraq and Afghanistan, in which weapons laws are a lot more relaxed? Weapons laws, or they are not existent, or if they're existent, they're not enforced, as in the case of Afghanistan, where carrying a weapon is an everyday thing of everybody. One of the issues in Afghanistan was at night the coalition forces were striking Afghans that were carrying weapons around at night with the belief of they're at night, chances are they're not up to any good, and they're carrying weapons. Well, what happens? Afghans work at night in the summer because why? It's too hot, so you kill civilians. Mm-hmm. So you have that background. But also, 1977, when these things are drafted, was the most common weapon of usage by the insurgency. Grenades, AK-47s. The grand majority of KIAs, killed in action, and wounded in action, are a result of these type of weapons. But what happens now in Iraq and Afghanistan, where 90% of the wounds are as a result of improvised explosive devices, IEDs. They're not running around with AK-47s trying to shoot an outpost. They're putting IEDs out there. So how can we apply the showing a weapon, carrying it openly, on the deployment to the attack or during the attack, when in fact an IED may explode in an hour or may explode in a couple of days? Mm. How do we reconcile that when now they have moved from carrying or shooting with AK-47s or throwing grenades to employing IEDs, which is a more remote weapon? And now the thing is, well, should we ban IEDs? Well, we shoot artillery, which is rather indirect as well. We bombed from planes, which is rather indirect as well. They're doing exactly the same thing that conventional forces do. And that's problematic.
And so do you think that it's true to say that international humanitarian law favors the sort of traditional, perhaps, traditional armies like you were talking about the French army versus whatever in Europe? Does it favor those kinds of armies, or is it just that it was written for them and now we're trying to apply it to different kinds of conflicts?
I would say the Geneva Conventions that were written up to 1949, they were designed with the large armies fighting against each other.
Yeah.
And they didn't want to really extend it to insurgencies because a lot of these countries had what they call domestic issues with their colonies, so they didn't want to extend it. Got it. In 1977, they tried to encompass insurgencies with all these different changes. But they encompass insurgencies according to what insurgencies and how insurgencies fought in the 1950s, 60s, and 70s. And as technology has changed, as way insurgents recruit, or even not recruit, inspire attackers that they haven't even met. Things have changed quite a bit. And which has to do with my research are these two books, or particularly this particular book, The Additional Protocols, are they outdated? Are they not even up to the standard to regulate insurgencies? Or are insurgencies, according to these definitions, not insurgency warfare does not apply, insurgency warfare regulation does not apply to these type of insurgencies? That is my question.
Yeah. Maybe what is also good to know is that's another problem underlying international humanitarian law. Is so far what we've been talking about are the full rules, and one first step that you always take if you want to see if international humanitarian law applies is that you need to classify the conflict, because basically the Geneva Conventions and the additional protocols are mostly focused on wars between states. So you have one state fighting another state, but insurgencies, are usually not states. They're armed groups, and in classic international law, you might even say like, well, okay, maybe it doesn't apply because it's a conflict to which only the law of the country in which it is taking place applies. But actually, from an early stage, it was recognized that some of those conflicts can be so intense and can be so serious that you want international humanitarian law to apply as well. Mm. In that case, they're classified as a non-international armed conflict, and originally there was only a very, very limited set of rules that applies to them. But one of the developments in this field of law in the last few decades has also been that more and more rules that originally only applied in international conflicts also became applicable in those non-international, or I should say non-international because because it's more of a technical term, but these kind of conflicts. But in the law rules that apply to those non-international conflicts, you don't really have a principle of distinction, and all kinds of other rules and concepts don't automatically apply anyway. So it's kind of like so quite often some of the rules apply, some don't, but it doesn't really make things much easier. Mm.
I'd like to add that one of the Protocol 2 talks about some of these insurgencies. One of the requirements for the Protocol 2 to apply is that these insurgencies, these armed groups, occupy terrain. The UN came out with a fantastic report regarding the war in Syria, in which not occupying terrain was a tactic of the insurgencies because it became a liability. So what we understood back in 1977, things have changed. Things have changed the way they attack, the way they conduct warfare. Some of the Yugoslavia tribunals and also Additional Protocol 1 talked about an organized group with a responsible command, with a level of discipline and stuff like that. What happens with all of these groups is that they understand that being completely decentralized is an actual advantage. Because otherwise you have the Shining Path situation of Peru. The moment that you take the head out, which was Abimael Guzman, the movement collapses. By being decentralized, you have the perfect opportunity that you have a ton of cells, you have a ton of little groups. You kill one, you still have 1,000 to deal with. So it's kind of like, that when you go to the fair and you have those little pop up little animals that keep showing up, you have a little hammer, you hit one, you think you're done, oh no, you got like 10 more coming up. So it's exactly the same thing, and it becomes an advantage to them.
So then is it also true to say that international humanitarian law kind of presumes a level of control, and when you don't have control, then it's much more difficult to figure out how international humanitarian law applies? I
would argue that the international humanitarian law, Additional Protocol 1, Protocol 2, was rather tailored according to the 1950s, 60s, 70s guerrillas, insurgencies, which had a level of control because they wanted to mirror an army. They were in search of establishing a nation. Mm-hmm. And in order to obtain support from the international community, they needed, we are the new government, or be recognized as you are the new government of the Republic of Guinea, the Republic of Angola, the Republic of Mozambique. And these insurgencies are a little bit different now, and their goals are completely different.
Yeah, and to answer your question about control standards, they do play a large role also in deciding what kind of rules are applicable. Also to such an extent that if you're dealing, for example, with a conflict between, on the one hand, state forces, and on the other hand, what looks like an organized armed group, so it could be insurgents, or it could be a rebel group, or a revolutionary group, anything, the international humanitarian law allows for the possibility that that group actually is really strongly supported or maybe even controlled by another state. And if you can prove that that is the case, then the rules that become applicable are not those for a non-international armed conflict, but rules for an international armed conflict.
So there's more protections that come in when you have that.
Yeah. So the type of, well, I mean, there are different forms of control, but I mean, control over one armed group by a state can play a huge role in which rules are applicable. And well, and as Anders just explained, what an armed group itself controls can also determine, okay, do we see this as a conflict in which we apply IHL or not?
Yep. Yeah. And I want to ask, obviously this is a huge question. I don't expect to go into all the details just now, but you know, one of the conflict that has received the most attention in the news most recently for us here has been the conflict in Ukraine and the Russian invasion of Ukraine. Do we see these dynamics playing out there?
Which dynamics are you thinking about?
So do we see the dynamics that we've been talking about? So the asymmetrical kind of conflict, the insurgency type warfare that Andres has been talking about. Do we see those dynamics playing out in the conflict in Ukraine, or does that look more like a traditional conflict?
Well, it started on the one hand, it's a classical conflict, right? Because it's an interstate conflict. It's kind of interesting because the way we have been teaching it also in the international humanitarian law course in Maastricht, the last few years we're always talking about the conflicts in Syria and Yemen, which are still continuing but are unfortunately receiving less attention now because of the war in Ukraine. But there are insurgent groups and all kinds of other things going on. And now suddenly you get, kind of like a classical interstate conflict. So in that sense, you would say, the traditional rules do apply, and they seem to be applying. But it is indeed true that there are certain features of the conflict which show that it is very much a 21st century conflict. And one of them is that it's not a conflict between equals, right? Russia has a much larger and, on paper, more powerful military than Ukraine. And in the beginning of the conflict, many people were also thinking that, Russia would just prove victorious quite quickly. But what Ukraine has been doing is that it has been applying quite a few insights from insurgency warfare also in its fight against Russia. And I think, Andres can give quite a few examples of that. But before he does, what is also interesting to note is that some of the things that Ukraine is doing, because a lot of attention has gone to violations of the rules of war by the Russians, but some of the strategies and tactics that Ukraine is using are also maybe a bit difficult to reconcile with IHL. But if you would if you would talk to the Ukrainian government and tell them maybe that's not fully compliant, they would say we are much weaker and they're much stronger, so we give ourselves some leeway in that regard.
So it's in this Ukraine is a fantastic example, because we have to go back to 2013, 2014 when the conflict began with Donetsk region and with Donetsk and Luhansk, the Donbass region of the Ukraine. And you would think that's a perfect example of an insurgency supported in some kind of way by an external country like Russia, and they fought an insurgency warfare where IHL would apply additional protocols 1 and 2. However, additional protocols 1 established that these insurgent groups are supposed to have a level of organization. And the Dutch court in 2020 said that IHL doesn't apply, in particular to the downing of MH17, because those groups didn't meet that level of organization, which was quite an interesting decision. So in a conflict where you would think IHL would apply, because it's an internal or possibly internationalized conflict, according to the Dutch court, it does not. So, and then you have the invasion of February, the end of February, when you have a conventional type of warfare, Russia invades Ukraine, and Ukraine is trying to defend itself. And there's a little misnomer being thrown around in the media, the resistance fighting. Well, they're defending themselves, just like any country would that's being invaded. They're defending themselves, and they are, and they're doing a really good job at it. And they're trying to slow down, trying to defend Kiev, Chernihiv, and all these wonderful countries, wonderful cities. I'm sorry. And now they're going on a counteroffensive. There hasn't been any guerrilla warfare whatsoever, any proper insurgency warfare whatsoever, for the exception of lately in Melitopol, a city not too far away from Mariupol, in the area that was already occupied by Russia within the first month. And what you have now there are groups of insurgents, pro-Ukrainian insurgents, conducting operations, killing Russian soldiers. They're attacking trains. This is very typical 1940s type of destroying trains that are resupplying or moving Russian troops around, and just taking, once again, those 1,000 little bites at a time against the Russian army. And they're doing that. Now the question is, according to additional protocol, these guys are supposed to have a certain level of organization, a certain level of discipline. Do they? The Ukrainian army, Kiev is talking about, yes, they're falling under our control, but are they? Now, if you look at the Palestinian effort during the Intifada, Arafat talked a lot about, oh, they're under my control. Well, they really weren't. He talked that they were, but they really weren't. They're doing their operations without his guidance. So now the question is, they would have to have a relatively robust organization, a relatively robust command and control, as well as a level of discipline with the proper chain of command. Do they have that? And if they do, then this would apply. Otherwise, those fighters in Melitopol will not fall under IHL, and they'll be considered criminals or bandits.
We're coming kind of towards the end of our time. I just wanted to ask briefly before we finish. We've talked a lot about, how IHL applies, international humanitarian law, how it applies, whether or not there have been violations. But how is this enforced in international humanitarian law? And how is it implemented? So did you, for example, receive any training on international humanitarian law when you were in the forces?
We did. It was rather basic. And then once you actually go into a particular theater of war, you get what's called a rules of engagement card, which tends to change very isotopically. And on that, what usually ROE cards, what we call them, it re-emphasizes some basic principles of international humanitarian law, as well as some principles for that particular conflict. And it could be something as simple as part of your engagement, you can use deadly force to keep criminals from looting local areas. In some conflicts, you're expected to do that, and some others don't. But do they really reflect IHL? Not all the time.
And are there, what are the main enforcement mechanisms for IHL? Are there kind of courts that people would go to?
I think you need to distinguish between two different, types of enforcement, because the point of international humanitarian law is actually a preventive one, and to regulate armed conflict while it's taking place. So there you're focused on implementation. So the states are supposed to provide training indeed to their forces, but also to make sure that actually the general population knows about those laws. But then when you're talking about enforcement after a conflict has taken place, basically, often, unfortunately, it's already a little bit too late. But the mechanisms for that are growing, because Andres already mentioned the ICTY, which is the International Criminal Tribunal for former Yugoslavia. There have been a number of other international criminal tribunals as well since the 1990s, and now we have the International Criminal Court as well. And more states are signing up to it, although some of the ones who are most involved in armed conflicts have not, so that's a bit of a problem. But other options are also that states try to address it with each other, or that they launched cases between each other and try to enforce the rules in that way. But it is a little bit of a patchwork, so we don't have a very coherent system, but there are definitely some mechanisms to hold both individuals who have violated these rules accountable, but also to hold states responsible. A last option is also that victims of armed conflicts can sometimes bring claims against their states. Well, they would always do it first before their own courts, but if that doesn't work out, some international human rights mechanisms also have the power to say something about that, or to maybe award damages.
So lots of room for improvement, but perhaps getting better slowly, maybe.
Hopefully.
Hopefully. One thing that we like to do before we finish up is I'd like to ask you to be as serious or as silly as you like. But if you could add one new human right to human rights law or one new kind of aspect to international humanitarian law, what would it be? Wim?
I was going to pass it to Anders. Yeah, I think, well, to an extent it exists, but it's not fully systematized. But I think it would be a right to truth sounds a little bit big, but I think there's room for better rules on establishing what has happened in armed conflicts after they have taken place, and it would be good maybe to formulate that as an independent obligation rather than to make it an aim as it is now. It's an aim of international tribunals, and some people say like individual victims might be entitled to it, but maybe if governments were obliged to basically conduct their own research into what had actually happened and publish that would be a very good thing.
I like that. Yeah. Andres, if you could add one more.
Absolutely. I was actually thinking about this. I would say the right to tacos. I'm serious. I mean, have you ever seen an angry person eating tacos? Have you? No. Usually there's somebody with a smile, right? Well, it's not the answer to world peace, but it's a step in the right direction.
Step in the right direction. Good. So we have a right to truth and a right to tacos. I like the combination. Thank you very much, Wim. Thank you very much, Andres, for a really interesting conversation. Thank you very much, everyone at home. If you would like to find out more about the Maastricht Center for Human Rights and the members of the center, then you can find out more on the Maastricht Center for Human Rights website. Wim and Andres, if people want to find out more in particular about you and your research, where can they find you?
Well, I have a profile page on the Maastricht University website. I have a Twitter account, which you can find there as well, but I'm not very active, so I recommend just to visit the website.
And I have a Twitter account, and I'm going to be more active, so it's NIVUELVE, Nivuelve. You'll find me there.
Thank you very much, both of you. Thank you to everyone at home, and see you next time.